All right, good afternoon. It is 1 o'clock on Friday, January 30, 2026. We're here in case number 26-90103, Sachs Global, on an emergency motion. Can everyone please mute their lines? There's a lot of people on the line, and I'd like to avoid going to the hand-raising feature. All right, make sure to go to my webpage and note your appearance, because that's the way we keep track of formal appearances in this case. So why don't we get appearances and then we can proceed.
Good afternoon, Your Honor. This is Betsy Feldman from Wilkie Farr and Gallagher on behalf of the Global Debtors. Can you hear me all right?
I can hear you fine, yes.
Thank you, Your Honor.
Good afternoon, Your Honor. Michael Bearden on behalf of the SO5 digital debtors, and hopefully joining me soon will be my colleague Jared Martin. He is unfortunately tied up in another hearing, but should be free soon.
All right.
Good afternoon, Your Honor. Jerry Lee Miller, appearing on behalf of Simon Property Group from Pacific Office.
All right, thank you.
Good afternoon, Your Honor. It's Timothy Schilling on behalf of GA Group.
Chris Schilling.
Good afternoon, Your Honor. Chris Hopkins with Paul Weiss, Brooklyn, Norton, and Garrison on behalf of the ad hoc group of bondholders.
Good afternoon.
Good afternoon, Your Honor. Maggie Vesper of Ballard's Bar LLC on behalf of certain landlords, including Street Retail LLC and Fashion Outlets of Chicago LLC.
All right.
Good afternoon, Your Honor. Jennifer Valley of Kelly Dry & Warren on behalf of certain landlords, including GGP Retail, Bricksmore, and Regency Center. Thank you.
Good afternoon, Your Honor. Greg Hess on behalf of Capital One.
All right, let me just go around. Mr. Scott?
Brendan Scott from Claysett Winters, Druthers, Southern, and Stevens on behalf of BH Multicolor Corp, BH Multicom Corp, Unique Designs, Inc., and Richland Group, Inc.
All right. Ms. Ryan?
This is Abigail Rushing Ryan with the National Association of Attorneys General.
All right. Mr. Cirillo?
Good afternoon, Your Honor. For the record, Daniel Fiorello from Alderburg, PC, counsel for Bank of America as agent for the ABL DIP lenders.
All right, Mr. Ward.
Good afternoon, Your Honor. Nathaniel Ward, Wilkie Farr and Gallagher on behalf of the global debtors.
All right. Does anyone else, Mr. Castleman, do you wish to make an appearance? I can't hear you. You might be muted. No, you're still muted. Hold on. All right, try now.
Sure, Your Honor. David Castleman from Alderburg. I'm here with Mr. Cirillo, also on behalf of Bank of America as ABL agent.
All right. All right, I'm going to activate the hand-raising feature because we have a lot of people on, and it's 100. We have 150 people on. It's very loud. So just hit 5* one time, and I'll let you back in.
Conference muted.
All right, Ms. Feldman, are you a 646 number? All right, so let's see. 212 number. Ms. Ryan?
212.
All right, hold on. I mean, Feldman.
The number ending in 8633.
Right. All right. There's a 646 number on a line that I just opened up. All right, and then a 908 area code number.
Yes, Your Honor. Jason Hill,
of sales permits and gross, and I just wanted to note my appearance for the record on behalf of Alpha Scaparelli, SAS, and Deva Inc., which is spelled D-E-V-A.
Okay, all right.
Thank you.
All right. Ms. Feldman, are you taking the lead?
Yes, Your Honor, thank you. We are here today on an emergency motion that we filed yesterday concerning the global debtors store closing procedures. I'm joined today by my colleagues Jennifer Hardy and Nathaniel Ward. The global debtors chief restructuring officer Mark Weinstein is also on the line, as is Tim Schilling from the consultant GA Retail Solutions LLC. We wanted to thank Your Honor for giving us time on this emergency motion today. This morning, we filed a witness and exhibit list with 4 exhibits at docket number 530. First, the declaration of Mr. Mark Weinstein in support of the first days at docket number 530-1. Second, a copy of the consulting agreement at docket number 530-2. Third, a copy of the store closing procedures at docket 530-3. And finally, the declaration of Mr. Weinstein in support of this emergency motion. We would ask at this time that each be admitted into evidence.
All right, let's start with the last one first, which is Mr. Weinstein's declaration as it relates to this particular motion. Does anyone object to the admission of Mr. Weinstein's declaration found at docket 530-4 as his direct testimony in connection with this motion subject to cross-examination? All right, hearing no objection, that will be admitted. Does anyone object to the admission of exhibits 530-2, which is the consulting agreement, and 530-3, which is the store closing procedures, admission of those exhibits into evidence? All right, hearing no objection, they will be admitted. Obviously, to the extent anyone, oh, wait a second, I just opened the line for someone.
I apologize, Your Honor. This is Jerry Lee Miller. I had raised my hand earlier to make my appearance, but that got made.
Okay. All right. All right. Hearing no objection to admission of Exhibit 530-2 or 530-3, those will be admitted. As it relates to 530-1, that's the general background petition which had been admitted just for purposes of the background. I'm going to take judicial notice of that. I don't think that pertains directly to this motion. It's more of a background. So the exhibits are admitted.
Thank you, Your Honor. As Your Honor may recall from our first day hearing a few weeks ago and certain motions that we filed in these cases to date, the debtors operate the Saks Off Fifth brand, which offers discounted luxury goods to customers. The Saks Off Fifth brand has 2 selling channels, 74 brick-and-mortar stores that are operated by the global debtors, and an e-commerce site that is operated by the SO5 digital debtors. The global debtors have also been winding down operations at the Neiman Marcus Last Call stores as well. Unfortunately, all 3 channels have suffered in performance of late, and last week, Your Honor heard a motion by the SO5 digital debtors for authority to wind down the e-commerce site. Today, we're before you seeking authority for similar relief with respect to the stores. The global debtors' strategy with respect to the stores is to resize the store footprint down to 12 and to use those stores as a liquidation channel to sell excess inventory. In furtherance of this strategy, by this motion, the global debtors seek authority to enter into and perform under a consulting agreement with GA Retail Solutions, LLC, a copy of which is attached as Exhibit 1 to the proposed interim order. In addition, we're seeking authority to conduct store closing sales pursuant to certain proposed procedures that are attached as Exhibit 2 to the proposed interim order. Also, we're seeking authority to pay bonuses for non-insider employees of the closing stores and to approve modifications to certain customer programs. With respect to that last point, I'd like to point out that the SO5 digital debtors have joined in our motion with respect to the customer programs modifications. The purpose of that, Your Honor, was to coordinate so that we would ensure that relief is as clear and consistent as possible for Saks Off Fifth customers, whether they're shopping in-store or online. Since we filed the motion yesterday, we had a number of parties reach out to us to discuss specific aspects of the relief we are seeking, including the attorney for the U.S. trustee, certain landlords of the closing stores, and other interested parties. However, there has been one objection that was filed to the motion this afternoon, I believe by Simon Property. Before I go too much further, I wanted to make a few statements on the record in response to points that have been raised over the past 36 hours. Judge, you may hear from a lot of vendors about issues that were raised at the first day hearing, but nothing in this sale closing procedures motion, which true to its name is procedural, affects what the court heard as to the vendors on the first day, and any remaining issues from the first day that aren't yet resolved, and again, we really do hope to resolve them all before any final order is entered, that those will be resolved at the hearing on the 13th. But this hearing is not the forum to address those issues unless they are specific to the relief that's requested here. Consistent with what was said at last week's hearing for the SO5 digital debtors, we care very deeply about the debtors' brands and relationships, and this order is not intended to diminish any vendor's rights in inventory or otherwise, and likewise the global debtors' rights. Next, the global debtors will not expand the relief sought in the motion to stores beyond those that are listed on the exhibit to the consulting agreement without seeking further relief from this court on notice and a hearing. Next, with respect to any side letters that are entered into under the proposed interim order, Great American and the global debtors will work in good faith on the terms of such side letters. If a landlord had a breach of contract claim arising from the closing of the stores and any sales that are conducted under these procedures and has failed to enter into a side letter, those rights are preserved and can be dealt with in the assumption and rejection process later on in this case. Finally, following this hearing, we will file a revised proposed form of interim order reflecting some changes that we have agreed to make with certain parties of interest. In the interest of time, I'll ask if Your Honor has a preference on how we proceed. I'm happy to answer any questions that you might have or proceed on the merits, or otherwise we would ask that the court enter the proposed interim order.
All right, so I have one or two questions, and then I'm going to let the other parties speak. And then the other overriding concern is, I saw from the docket sheet that the organizational meeting for the unsecured creditors had been yesterday, I believe. And so I don't know if the unsecured creditors committee had appointed counsel yet, but I would love for them to be able to see this before I consider entry of the order, but we'll talk about that at the end. The only question that I had was, so you filed a motion at docket number 32 to reject certain leases. Are these 74 leases included in that motion?
No, Your Honor, they are distinct.
Okay, so there's currently no motion to reject any of the leases that are covered by this motion?
That's correct, Your Honor.
Okay, all right. That actually simplifies things for me. All right, let me hear from anyone else who would like to be heard. And,
Your Honor, can you hear me?
yes.
Perfect. Jerry Lee Miller from Sidley Austin here on behalf of Simon Property Group. Your Honor, we did file an objection at docket 533 immediately before this hearing.
Yes.
My client does not, in principle, oppose the debtors conducting the store closing sales. We understand that's within their discretion. What we would like, Your Honor, is simply time. Time that's guaranteed to us by its due process clause and the bankruptcy code. Just for Your Honor's context, this motion was filed at 1:30 p.m. yesterday. We immediately reached out to Great American with our form of side letter agreement. Simon is obviously a very large landlord. They've got a form of agreement that they negotiated with, standard terms and conditions that they reach out to parties who are in similar circumstances and enter into an agreement with. We did hear back from Great American this morning around 10 a.m., but the feedback was simply that it was too close to the hearing and we weren't going to be able to reach a resolution in time. And so, Your Honor, we simply ask for that time to reach a resolution. We understand that the debtors filed this on an emergency basis, but frankly, Your Honor, they've been in bankruptcy for 2.5 weeks. So to the extent that there was something to be negotiated, they could have been working with the landlords for the past 2.5 weeks so that this could have been filed on an agreed-upon basis. Unfortunately, that's not what happened. We just learned about it when it got filed yesterday at 1:30 p.m. And so we should not now be forced into an arrangement on one day's notice simply based on the promise that they'll work with us in the future. And going to that promise, Your Honor, while I very much appreciate their willingness to work with us in the future, and I'm confident in the Simon Group's ability to consensually resolve these, for context, they have resolved approximately 90% of these that they've done. The entry of the interim order today would change the playing field, Your Honor. So when that interim order gets entered, the store closing sales could immediately commence, and we understand that they would immediately commence, which constitutes post-petition breaches of our leases and which causes Simon Property Group damages. All we're asking for is for these side letters to be negotiated in advance. And so, Your Honor, we'd ask for simply more time before this interim order is entered, or that the signed and leases be carved out of the interim order, subject to the earlier of a consensual entry into a side letter, which we think could happen very quickly, or the final order.
All right. Anyone else?
Can you hear me?
Yes, I can, Ms. Ryan.
Thank you, Your Honor. And for the record, this is Abigail Ryan with the National Association of Attorneys General. We just learned about this filing this morning, and I have been coordinating with some AG's offices, but I'm sure that the majority of them have not seen this or the proposed order. And since it does impose liquidating sales laws and dispute resolution processes, I'd really like to be able to touch base and make sure the AGs know about that. I do know a couple of things have been raised. I believe we can absolutely find language that will address these issues. We just need more time. The first issue is the dispute resolution process, as I read it, does not carve out police and regulatory laws to be enforced for human health and safety. And generally, when this language is used, I'm very familiar with it. It's in almost every Daniel business sales case. You do have a carve-out. And so that's the first issue. The second issue, AGs feel that consumers need to be able to return materially non-conforming goods if they get something like that at a sale. Third, it needs to address augmented goods as well. And so if other goods are brought in that are not of the facts of value or the debtors or what have you, they need to be clearly labeled so customers know they're buying an augmented good that is not part of the debtor's supply. And finally, since this is going to be very quick and these closing sales are going to go into a motion soon, we would like to have the customers notice through the debtor's website and social media apps because we believe that reaches more consumers more quickly. I believe the order said they would accept gift cards for the first 15 days of the sale. I don't have an issue with that, but I do have one question as to whether other stores that aren't closing, will they continue to accept the gift cards? And so if you have questions for me, I'm more than happy to answer them. Otherwise, I wanted my objection on the record, but I think we can probably find language that'll fix these issues.
Yeah. I think those are all issues that need to be addressed. I'm not sure that if they have to be in the interim order, we're going to set a prompt hearing on the final. So I suspect, and Ms. Feldman, if we can set it at the time of the final hearings on the 13th, or we could do it at a different date if it's more appropriate. But the 13th is all SACs, so we can certainly find a time to do it that day. So that's only 2 weeks from today. So I think that can be addressed at that time. Okay. Anyone else wish to be heard?
Good afternoon, Your Honor. Maggie Vesper of Ballard's Bar LLP on behalf of Street Retail LLC and Fashion Outlets of Chicago LLC. I rise today to echo the concerns raised by Simon Properties. Prior to today's hearing, in an effort to resolve our concerns, we previewed these issues with the debtors, and although we made some progress, we were not able to fully resolve all of our concerns. Our central issue is having signage and advertising in place at our clients' locations prior to the entry of a final order or the execution of a side letter. Many of the purported sale guidelines violate numerous provisions of our clients' leases, and there's no basis to invalidate or otherwise ignore these lease terms. Accordingly, we object to the commencement or continuation of sales at our clients' 2 locations under the proposed guidelines, unless and until there's a side letter or the court makes a determination at a final hearing on the sale guidelines. Our clients are willing to work with the debtors on the process for these sales, as we have done in so many other retail bankruptcies, and we would request that the release be conditioned on the entry of the latter of the entry of a side letter between the parties or the entry of a final order. We also have 2 specific line items that we spoke with Ms. Feldman about, but I'm not sure were incorporated in the proposed order, and I'm happy to address those now or wait for a time Your Honor would prefer.
I mean, I don't know what they are. I don't know whether they've been addressed.
If I can respond to that
Sure.
one piece, Your Honor, we'll continue to work with Ms. Vesper to address those 2 final line items.
Okay, all right. All right,
Thank you,
who else wishes to be heard?
Your Honor, may I do it?
Yes.
Brendan Scott on behalf of Richland Group, Inc. and Unique Designs, Inc. I just wish to raise, Your Honor, a point of clarification. In the consulting agreement, the definition of merchandise appears to carve out all memo and consignment goods, but there is something of a qualifier in there that says as identified by merchant. I think that means that the debtors are just going to send a list of all consignment and memo goods. So I want to be certain that they're not reserving the right to pick and choose which goods they think are on were received on consignment and memo. That to the extent they're going to pick and choose, that the party should have some consent right with respect to that. So I'm hoping the debtor can clarify that is truly all goods received on memo and consignment are carved out, and they're not reserving some right there to pick and choose.
Is that correct, Ms. Feldman?
That's correct, Your Honor.
Yeah, that's the way I understood it, and that's the way. This is almost identical to the numbers are different, obviously, but this is almost identical to the one that we signed last week with respect to the digital debtors, and that point was raised and addressed at that time. All right. Anyone else wish to be heard?
Your Honor, Your Honor.
Go ahead, Mr. Hess. Go ahead.
Yes, thank you, Your Honor. Greg Hess on behalf of Capital One. Capital One, as a reminder, is a provider of private label credit cards to customers of Neiman Marcus, the Bergdorf, Goodman, and Last Call debtors. The motion filed by the debtors, which includes the closing of 5 Last Call stores, impacts the ongoing relationship between Capital One and the debtors. After receiving the motion, we reached out to counsel for the debtor as well as the business folks at a meeting, and we raised a number of concerns with the process of the sales and the impact that it would have upon the ongoing customer program. I'm happy to report that we have reached an agreement as to many of the issues that were raised, and the debtors counsel has represented that there will be language added to the order to address those issues. At this point, from the statement of Ms. Feldman earlier on, apparently the revised form of order has not yet been uploaded or filed, so we have not seen it to make sure that it's in there. So we'll reserve the right with regards to those particular pieces. Having said that, there is one open issue that we have continuing discussions about, and that relates to a feature of the program agreement in which customers who do not have their card on their persons can have people at the store look up their account number. We believe that there are some issues that are raised with it. We have not been able to resolve that issue, and so we're reserving the right to possibly object to that particular provision before a final hearing, while we're going to continue to work with the debtors to try to resolve it outside. With that, hopefully we can get it resolved. Thank you, Your Honor.
All right, thank you. All right. Who else wishes to be heard?
If I may quickly, Your Honor.
Yes, sir.
Thank you. Once again, for the record, Michael Reardon on behalf of the SO5 digital debtors. As Ms. Feldman noted at the top, We have joined this motion, or we're parties to this motion, solely with respect to the provisions relating to customer programs. We've been working with the global side to make sure we're coordinating the timing and implementation of these changes. At least on the SaxOnOffFifth.com side, in connection with our liquidation sale, and on the Saks Global side, proposed store closings in order to limit customer confusion. We are at a point where we have, I think, these changes queued up and ready to go, and we're anticipating implementing them either today or tomorrow. So as we're discussing timing, we think it's important in terms of keeping our liquidation sale moving forward to at least have authorization on the customer program aspect of this order. Thank you, Your Honor.
Thank you.
May I be heard?
Yes.
Thank you, Your Honor. For the record, Jennifer Avelli of Kelly Dry. Again, on behalf of GGP Retail, Brixmor, and Regency Centers, we echo the comments of Ms. Miller and Ms. Vesper. We did reach out to Wilkie before the hearing, and a lot of these issues, frankly, we were usually able to resolve prior to an interim hearing, but because of the expedited nature, we were not able to in this situation. I hope that the revised order will address a lot of our concerns. I have seen some of Ms. Vesper's comments to it. I did just want to raise a few points. One being that we agree that until a side letter is signed because of the expedited nature, we would ask that no store closing sale signage is installed at our clients' locations. Two, we would like to be notified when the store closing sales are going to conclude at those locations. That's typically something we can address in a side letter, but it is important so our clients can adjust the windows to avoid the appearance of a dark store. And then ultimately, the sale termination date in the motion appears to be April 30th, but the parties have the right to extend that. And we would like to be given notice to the extent that the sale termination date is extended, just so that we're aware of what's going to be happening in our spaces. I think that's all I have for now, but again, I do just echo the comments of Ms. Miller and Ms. Vesper.
All right, anyone else wish to be heard? Go ahead, Ms. Did you hit 5-star? Okay, there you go.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor. Audrey Furniture with Clark Hill PLC, representing Scottsdale Promenade LLC. We also echo the concerns of the other landlords today. Primarily, our concern is expedited nature. Typically, we would enter into 5.
Our system will end this conference in 5 minutes. To extend this call for 1 hour, please enter the moderator PIN now. Your conference has been extended for 60 minutes.
Raise these concerns, and that we hope that we're going to be able to amicably resolve these before signage and marketing commences at our location.
All right. All right. Ms. Feldman?
Your Honor, if there's no one else who wishes to be heard, I'd like to respond just to a few of these points.
Sure.
Thank you, Your Honor. With respect to the landlord councils who have raised similar issues, I'll just reiterate what I stated earlier in my introduction. It's very important to us that our sale not be conditioned on an individual landlord's consent. And for that reason, we, with respect to any side letters that the parties will likely enter into, as I noted earlier, we will definitely continue to work in good faith with the Landlords Council to reach an agreement on those side letters. However, the exigency of these store closings is very palpable for these global debtors. With respect to the timeline of these cases, the store closing sales really do need to commence right now. They're slated to proceed for approximately 12 weeks in these cases. And if we expand the timeline beyond those 12 weeks, we will not only incur unnecessary rent charges beyond that time, but also we will incur additional case costs throughout these cases, which will really burden the debtors. For that reason, we cannot let the commencement of the store closings slip past the date that's projected in our motion, and for that reason, we would respectfully request the Landlords Council's objection with respect to the side letters needing to be entered before any store closings can commence at their stores be overruled.
When do you anticipate putting the signage up?
Your Honor, I believe that is happening on Saturday, but I will defer to Mr. Schilling if anything has changed. Hearing nothing, however, I think that's
No. He's trying to get on. Hit 5-star one time, Mr. Schilling. No. Just hit it 5-star one time. All right, there you go.
Okay. Thank you, Your Honor. Yes, Ms. Feldman is correct. The plan is right now to start the sale tomorrow morning.
All right. Anyone else wish to be heard?
I'm happy to. Oh, sorry. My apologies.
Your Honor, if I may briefly respond, we're not looking to condition anything on our consent, Your Honor. We simply want due process. This could have been negotiated over the last 2 weeks. They could have worked with their landlords. This is what would have been done in the ordinary course and what is done in 90% of these cases. And it just simply was not here. We should not now be punished for that lack of their reaching out and their working with the landlords. We're standing by. We're ready to negotiate this side letter agreement. We're confident we'll get one done, but we don't want to be punished and deprived of due process by an exigency of their own making. Your Honor, to a question you asked earlier, I understand that the committee is hiring counsel today. I also anticipate, as Your Honor does, that the committee's counsel will likely want to weigh in on this. And so at the very least, Your Honor, we would ask for till Monday, a delayed ruling until Monday to allow all the parties to work together and try to negotiate something.
All right. Does anyone else wish to be heard?
Your Honor, just briefly.
Yes.
Your Honor, I agree with what Ms. Miller said. I also just wanted to note our client, GGP Retail, is a committee member, and they are currently in the process of selecting counsel. The committee has asked that they do have, I know Your Honor noted it, I just wanted to reiterate, the committee has asked that they have the opportunity to weigh in on this motion.
All right. Anyone else wish to be heard? Hit 5-star one time.
Thank you, Your Honor. Can you hear me?
I can hear you, yes.
Yes. Good afternoon, Your Honor. Justin Burnbrock of Shepherd Mullen on behalf of Chanel, as well as Acris and Ralph Lauren. The counsel from Brookfield just reported what I was sent here directly from the committee call, which is ongoing on another line, to ask Your Honor. Chanel is co-chair of the committee. We are presently deliberating counsel selection and anticipate announcing that very, very soon. And so if there could be a very, very brief delay until such time as counsel has had an opportunity to weigh in on this after the committee selects it, it'd be greatly, greatly appreciated.
All right. Anything further? All right. So I view this as a relatively routine motion. I think it's perfectly within the debtor's business judgment to do this. I want to be sensitive to the committee and the landlords. So what I'm going to do is, subject to an agreeable form of order by Monday, I will wait until Monday at 5 to consider the order. If there isn't agreement, then we will have a continued status conference on this with respect to the order Tuesday at 12:30 at noon, and then the final hearing on this will be very quickly on February 13. But as I indicated, I'm inclined to, I really view this more as a timing. I mean, I'm going to approve the order. I think we just need to go through, allow the committee to look at it, and allow there to be discussions over the weekend during this. Now, as it relates to the custom program aspect of it, which is really very limited, I'm going to go ahead and orally approve that so that there isn't any, especially since the digital debtors have already started their process. So that's my ruling, but I really would like to have the weekend and all day Monday for people to look at this, and then I won't consider it. And unfortunately, Monday and Tuesday of next week, and probably Wednesday, I'm in a contested confirmation hearing. So Monday, Tuesday at noon or 12:30. Tuesday at 12:30. It'll be the only time that I'm going to have to actually look at this. So it's a brief delay, but I think under the circumstances, it's appropriate.
Thank you very much, Your Honor.
All right. All right. Any other thing that we can do today? Oh, wait a second. Somebody else raised their hand. All right.
Ruling.
All right. Somebody from the 516 area code.
Your Honor, this is Dan Fiorello from Otterberg. I had raised my hand, but your ruling had addressed a question I was going to ask, so you could disregard the hand raised.
Okay. All right. Anyone else wish to be heard? Hopefully, I'll get an order with everybody to anybody's satisfaction, and I'll sign it 5:01 on Monday.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
All right. We'll be in recess to 3 o'clock. 2 o'clock.